Mrs. Kingston.
My Lord, on this appeal, I appear for the appellants, together with my learned friends Mr. Edward Craven and Mr. Thomas Fairclough. My learned friends Mr. Charles Gibson, King's Counsel, Mr. Adam Effenstall, King's Counsel, and Miss Freya Foster appear for the respondents.
Thank you.
My Lord, in terms of timing, it would just be helpful to check if the court is proposing to sit until 4:30 or...
No, the court never sits until 4:30. We sit until 4:15, and tomorrow I have to rise before 4 o'clock. So we'll sit at 10:15 tomorrow, but that's, I'm afraid, the best we can do for you. So we're going to have a slightly tightened timetable. The second thing is we will take no breaks for transcript writers. I'm afraid we never do. And yes, apart from that, on we go.
Thank you, my Lord, for that indication. We will finish our submissions 15 minutes before the end of the day, and Mr. Gibson will commence his submissions 15 minutes before the end of the day.
You'll do what?
We will finish our submissions 15 minutes before the end of today, so at 4 o'clock.
Oh, right,
Mr.
okay.
Gibson, I've agreed with him, he will start his submissions at 4 o'clock.
Okay. All right. We'll see how we go. I wonder if that screen could be moved. That really is very much interrupting the view of
Yes, of course,
the court. I'm sorry, if it's too difficult, it's just these, you know, the screens have to be sort of slightly manipulated so we can see the participants in the case. Now I shall be watching it to see if it doesn't fall off. Okay, very good. On you go.
My Lord, this is an appeal from the judgment of Clive Sheldon, King's Counsel, as he then was, pursuant to permission to appeal granted by Lady Justice Andrews. With all due respect to the learned judge, we say he was wrong in respect of the first and second defendants to decline to exercise jurisdiction, which the claimants had established as of right, and to stay those proceedings. And in respect of the third defendant, to declare that the court has no jurisdiction and to set aside the order of Master Giddon, dated the 3rd of October 2022, granting permission to serve out on the third defendant. We say he was wrong in his application of the law and fundamental principles governing the court's jurisdiction, including in his application of the central cases in this area, including the Spiliada and Love and Cape. Our detailed reasons are set out in the grounds of appeal, Call Bundle, tab 4, page 65, and the order granting permission is at Call Bundle 8122. The order granting permission grants permission on all grounds on the basis that the appeal has real prospects of success. It's also notable that Lady Justice Andrews would have granted permission on the basis of the importance of the issues raised by this appeal, even if the merits threshold had not been crossed. Today we will divide our submissions. I will address ground 1 and Mr. Craven will address ground 2. In terms of the structure of my submissions, I propose to address the court in 4 parts. A very brief introduction on the underlying case and the importance of the issues on the appeal. Secondly, an overview of the judgment. Thirdly, the legal framework. And fourthly, I'll turn to the individual grounds. My Lords, we rely on our skeleton argument and 2 supplementary notes, all of which are in the core bundle. My Lord, all cases are important to the claimants, but this case is also important because of its subject matter. The claims make allegations of a very serious nature against well-known UK companies. The claims concern the conduct and activities in England which resulted in very serious harm abroad to extremely vulnerable migrant workers from 2 of the world's poorest countries. The claims concern allegations of breaches of fundamental human rights and modern slavery, which has been described as the scourge of our time. The defendants describe these claims as novel. We agree. They're an attempt to hold UK companies to account for injuries and loss suffered by vulnerable individuals who were subjected to forced labour and shocking abuses while manufacturing products sold by those UK companies. The claimants are 23 impoverished migrant workers and one relative of a deceased migrant worker. Their journey starts in Nepal and Bangladesh, from where they travelled to Malaysia to work. Only 5 of the claimants are now in Malaysia. The others are currently in Nepal, Bangladesh, and in one case, the UAE. Although the claimant's journey starts in Nepal and Bangladesh, the story of this case starts in England. The 2 principal defendants, the first and second defendants, are UK companies registered in 1985 and 1991 respectively. They employ thousands of employees and executives in England, and it is in England that the policies and standards on modern slavery and supply chain responsibility, which are applied across the world, are formulated and promulgated. The claimants originally intended only to sue the 2 UK companies, but the decision was taken to join Dyson Malaysia as the third defendant following correspondence from the UK companies, which revealed that Dyson Malaysia also had an important role in relation to the subject matter of the claims. And the limited evidence available to the claimants demonstrates that the third defendant works closely with the UK companies in the performance of supply chain monitoring and enforcement. My lords, the claim is legally and factually complex. Claims against all 3 defendants seek to establish the civil liability of a non-employer said to arise because of significant control exercised and held out to be exercised over the conditions and treatment of workers in supply chains. The focus of the claim at trial will be on the acts, omissions and knowledge of the executives and employees of the UK defendants. The legal basis for the claims against all 3 defendants are in tort, negligence and joint liability for other torts, and unjust enrichment. For the purposes of this appeal, as it was at first instance, it's common ground that all of the claims have real prospects of success. There's been no application for summary judgment by the defendants, no argument that there are not real prospects of success against the English defendants, as there was in cases such as Vedanta and Warby. It's agreed that the Malaysian defendant is a necessary and proper party to the claim against the English defendants, and that it's reasonable for the court to try that claim. These are important concessions, and they should not, in our submission, be underestimated or overlooked. As a result of those concessions, this court proceeds on the basis that the claims are well-founded in fact and law against all 3 defendants. This means that there's a real prospect of success that all 3 defendants are liable for unlawful involvement in and profiting from modern slavery, and that the claimants have each suffered actionable harm. There's a very significant disparity of arms between the claimants and the defendants. The defendants are part of the Dyson Group, one of the wealthiest and most profitable privately owned technology and manufacturing groups in the world. The 24 claimants are amongst the poorest and most dispossessed individuals on earth. In challenging the jurisdiction of the court, the defendants asked the court to stop claims which are already well developed from going ahead, where 2 of the defendants already have chosen to be domiciled. And the jurisdiction challenge should be viewed in the context that nobody disputes that a trial in this country would be fair. In this context, we say it's particularly striking that the English defendants were, until very recently, the end of August 2024, vigorously pursuing their own claims in the same division of the High Court, seeking remedies for alleged harm said to arise out of the British media's reporting of the client's allegations in the present case. And the impact of those proceedings is the subject of Ground 1D. Now, my lord, moving on to the importance of the legal issues in this appeal, this case is important legally because post the UK's withdrawal from the EU, the jurisdictional regime has changed significantly. Save in transitional cases, the EU regulation on jurisdiction and enforcement of judgments, the Brussels regulation, no longer applies in the English court, and the English rules of jurisdiction now apply to all cases. So the legal framework for claims against companies domiciled in England is now different, and in 2 significant respects relevant to this appeal. Firstly, the English court's jurisdiction over parties domiciled in England is again solely based on service and presence. It's no longer governed by Article 4 of the Brussels regulation. And secondly, and importantly, the English court can now decline jurisdiction in respect of claims against parties domiciled in England on the basis of the doctrine of foreign non-convenience. While the Brussels regulation applied, as the court will know, following in particular the judgment of the Court of Justice in Owusu and Jackson, jurisdiction based on domicile was mandatory, and the English court had to take jurisdiction over the claim. There was no scope for the court to decline to hear proceedings brought against a person domiciled in England on the basis that the courts of another state would be a more appropriate forum. So as a result of Owusu, for at least the past 20 years, there's been no need or opportunity for the court to consider the proper approach to an application by an English-domiciled defendant on the grounds of foreign convenience. Moving to the second part of my submissions, I was going to take an overview of the judgment. The judgment is at Core Bundle 7, page 75. My lords, it's worth just looking at paragraph 2 at the question the judge thought he was being asked to decide. I was asked to consider whether the trial of the claimant's actions should take place in England. My lords, for reasons I will develop, we say this encapsulates the problem with the judge's approach. In summary, this is not the relevant question, even at a high level of abstraction. In fact, we say there are two overall questions: whether the first and second defendants have shown that Malaysia is clearly and distinctly more appropriate for the trial of this action, and if not, whether the claimants have shown that England is the proper place for trial of the claim against the third defendant. My lords, the judge sets out in section 1 the history of the proceedings. Paragraphs 4 to 13, he looks at the pleaded claim in the claim form and the particulars of claim. 14 and 15, he deals with procedural matters and applications by the defendants. 16, the undertakings given by the defendants in this case, long list of undertakings. At 17, he sets out the expert evidence. And in 18 notes that there's been no application to strike out or summary judgment, so he proceeds on the basis that the claims are have reasonable prospects of success. Section 2 deals with the defamation proceedings, which I mentioned. And then he sets out in section 3, paragraph 27 and onwards, the law as to jurisdiction. 27 to 39 is the legal framework on foreign convenience, ground 1, which I'll focus on, and then from paragraph 40, the judge sets out the law on ground 2, a real risk that substantial justice will not be obtained. So I want to look briefly at the first part, 27 to 39. 27 to 29, we say, are unremarkable. Standard statements on the burden and standard of proof with respect to the two applications before the judge. Paragraph 30 is worth pausing at. This focuses on cases with multiple defendants, and the judge says the instant case involves a mix of both service in and service out. And it goes on, in these circumstances, and then quotes from Lord Briggs in Vedanta, the court is looking for a single jurisdiction in which the claims against all the defendants may most suitably be tried. My lords, I'll look at Vedanta in some detail later this morning, because in our submission it's very important to read the words of Lord Briggs in context. Moving on then to paragraph 31, the judge sets out, refers to Tugashev and Orlev, an important case setting out the
Sorry, just before you leave paragraph 30.
Certainly.
Is your submission that the judge was wrong to say that in a mixed case one's looking for a single jurisdiction in which the claims against all the defendants may most suitably be tried?
Our submission is that it's too simplistic a statement of the law, and we say there is no separate test in a mixed case. In fact, it's defined, a mixed case is being defined as a case where there's service in and service out. We say there's no separate test, it's simply spiliada, and it's incorrect to approach the case on the basis of some separate test. 31, the judge refers to a sheriff and all of which contains a helpful statement of the law and related proceedings, which we'll look at.
So which paragraph?
31, my lord. Yeah. And sets out, ends up with that paragraph referring to the well-known words of the tail not wagging the dog, which words of Miss Justice Blackburn, I think, in the Pacific case. 32 to 34, we say, is also unremarkable, referring to Spiliada and the exercise. It's not a discretion, it's a value to the exercise, and look at the issues. 35, I draw the court's particular attention to. At stage 1, the court examines the connecting factors between the case and one or more jurisdictions in which it could be litigated, and refers to Lord Gough in Spiliada. It's the forum with which the action has the most real and substantial connection. The judge then quotes again from Lord Briggs in Vedanta, and I do highlight this quote. In this quote, Lord Briggs gives examples of connecting factors. These include, and then lists some connecting factors. And as we'll see, the judge adopts this list when he looks at, carries out his evaluation of the forum. So practical convenience, availability of common language, system of law, and place where the wrongful act or omission occurred, and place where the harm occurred. So those four connecting factors highlighted by Lord Briggs forms the first four connecting factors which the judge looks at. But notably absent from that list is, for example, the location of the parties as a connecting factor, and that's one of our complaints about the judgment. Both that list and the equivalent list in Spiliada, which we'll look at, obviously are not intended to be complete codes of the connecting factors. They both say the connecting factors include. Lord Gough in Spiliada does include the location of the parties, but Lord Briggs doesn't in that example. My Lord, moving on then to paragraph 36, the judge refers to the dicta of Lord Manson, VTB, that the place of commission of a tort is a relevant starting point. And then 37, we're back to Vedanta and a multiple defendant case, where defendants domiciled in England, commonly known as anchor defendants, have agreed to submit to a foreign jurisdiction, but the claimant has made a deliberate choice to sue in this forum and has thereby engendered the risk of irreconcilable judgments. It would offend the common sense of all reasonable observers to think that the proper place for this litigation is to be conducted was England. Now that's a quote taken from Vedanta. Again, I'll come back to that, but we say it's taken out of context. That's the application of the law in Vedanta to that case. It's not a statement of principle. And then 38 and 39, the judge sets out, particularly 39 by reference to Lord Mans, the classic statement about the relevance of governing law. And then from 40 onwards to 52, that's on the ground to access to justice. So we don't need to look at that at the moment. My Lords, if I could direct your attention then to paragraph 83. The judge sets out, after the statement of the law, the parties' submissions, and then at 83 82 starts his discussion, page 99, and then 83 starts his discussion of Spiliada stage 1. Now, the first thing I note is that there's no reference here in his discussion to the fact that there's two separate applications, that there's burdens of proof on different parties, or the starting point for jurisdiction being different between the first and second defendants domiciled here and the third defendant. So the judge goes straight into looking at the connecting factors. And as I say, the little Roman numerals 1 to 6, which are the connecting factors he looks at, are straight. The first four are straight out of Lord Briggs. So first of all, practical convenience is what he looks at. And I'm just looking at headings at the moment. We'll come back when I do the grounds of appeal to look at the specifics. But 84.1, practical convenience. Little 2 is at the bottom of page 102, paragraph 96. There's no completely common language for each of the witnesses. Little 3 is at 97, the system of law. Little 4 is 102. The issues in this case took place in both England and Malaysia. Little 5 then, 5 and 6 are new compared to Lord Briggs's list. 5, the documents relevant to the case are held in both England and Malaysia. And little 6, 109, there's a real risk of multiplicity of proceedings and irreconcilable judgments. As I say, when I come to the grounds of appeal individually, I'll look at these in more detail. But I just note that in little 6, on multiplicity of proceedings, the judge considers a number of things, possible proceedings in Malaysia, the libel proceedings here. The one thing he doesn't look at, that one might expect him to look at, is the impact of the claims against the English defendants on the question of forum vis-a-vis the third defendant, the Malaysian defendant. And that's what many of these cases focus on, that aspect of multiplicity of proceedings, but we say it's very striking that the judge doesn't consider that. And that's partly, we say, because he's not looking at the application separately. He is just looking as a whole, as opposed to individually. My lords, the judge's conclusions are at 122 and 123 on Spiliada 1. 122, the judge recites Spiliada. Clearly, in Malaysia is another available form which is clearly and distinctly more appropriate. He then says the centre of gravity in this case is Malaysia. That is where the primary underlying treatment about which the complainant complaint took place, and is therefore the forum with the most real and substantial connection. Now, I'll come back to this, but we say, first of all, the test is not centre of gravity. It's a shorthand that's sometimes used by the court, but one that must be careful about its use. And secondly, certainly this conclusion is expressed by reference to a single factor, so the primary underlying treatment, and so therefore the forum is the most real and substantial connection. The judge then goes on, Malaysian law is also the governing law, and there are good policy reasons for letting Malaysian judges consider the novel points of law. And one of our grounds of appeal focuses on that. And then at the end of paragraph 122, the judge moves on to the third factor, the risk of irreconcilable judgments resulting from the defamation proceedings is an important factor, but it does not tilt the balance in favour of the English court being the proper forum. And we say that use of that language suggests that in the judge's mind it was a close call on the forum. At 123, my lords, the judge looks at the submission made by Mr. Harmer, King's Counsel, that the court could sever the claims and just allow the claims against the first and second defendants to proceed. But he says he agrees severance would be permissible in principle, but it would not make any difference to the outcome at stage 1. The factors that have driven the conclusion in the previous paragraph apply to the claim against D1 and D2. Whilst it's correct that their alleged actions or omissions took place in England, any claim against them is contingent on making out that harm was caused to the claimants in Malaysia. And I'll come back to our criticisms of that in detail. Then further, the governing law is that of Malaysia. And again, I note at the end of this discussion of Spiliada Stage 1, there is no reference to the fact that the separate applications or the burden of proof or the starting points being different. And what is clear from this is that the judge certainly does not analyse the applications separately, as was argued by the claimants at first instance that he should. Separately and sequentially, we say, first the English defendants, D1 and D2, and then moving on to D3. And that criticism is reflected in our ground 1A, but in fact it permeates the whole of ground 1 of the appeal. And we submit that the failure of the judge to approach this question properly explains in significant part the errors in his approach. My Lords, with that overview, I was going to move to the legal framework, to the third section of my submissions.
I mean, is it really an argument that he failed to separate the consideration of D1 and D2 versus D3, or is it really a complaint that he didn't pay adequate attention or give adequate weight to the fact that Dyson's home centre of gravity, that the first two defendants are the major defendants? I mean, which is it?
Well, we say it's the first of those, my lord. Well, both of those in a sense. So the approach is important. In a sense, the approach might not matter if then the judge did go on to do a detailed consideration of the connecting factors, but having in mind the starting point for jurisdiction in both cases is different.
I mean, you're going to have to show us some evidence about what these companies were, because we don't know. You know, you said they were incorporated a long time ago, the English companies, but we don't know what their turnover is, what their trading position is, what the Malaysian company is in comparison to the English company.
And I'm absolutely going to take your lordships to that as part of ground 1A.
And what's the summary? Is the Malaysian company much smaller?
So the summary is that the two first defendants have been registered in the United Kingdom for a very long time, over 30 years, that they are trading and operating companies. They employ 3,500 employees in England. This is not a merely formal registration in the jurisdiction. They operate here as
yes, but what about the Malaysian company?
The Malaysian company operates in Malaysia, is registered in Malaysia. In terms of the detail of the size, I'll need to come back to your lordships on that. But certainly in terms of employees in England, for D1 and D2, the evidence before the court is that there's a very substantial number of employees, 3,500, and that the businesses are operated very much in England. So I'll come back to that, if I may, when I'm looking at the second part of ground 1A, on the fact that the judge does not take the connections of the defendants, defendant 1 and 2, into account. But we do say the approach overall is important. So turning then to the legal framework, although the Brussels regulation no longer applies, jurisdiction in the English court is still very much governed by law and rules, and we say it's essential for the court to approach the issues in an analytical and structured way in accordance with the legal principles and rules. My lords, in these cases there's often talk about standing back and looking at the matter in the round, and in our submission standing back is fine and indeed helpful, but you can only do that once you've looked closer in, because before you stand back you don't know what you're looking at. On first principles, when we're looking at jurisdiction, the court needs to consider jurisdiction in principle between each claimant and each defendant. So the claimants could have issued freestanding claim forms against each of these defendants. And indeed, in principle, and depending on the basis for jurisdiction, the court is required to consider each claim brought by each claimant. Obviously, where jurisdiction is based on domicile, there's no need to look at individual claims because there's either jurisdiction over all the claims or none. But there are cases where the court declines jurisdiction over one claim because it doesn't fit into a ground of jurisdiction and takes jurisdiction over another. So we say it's really important to be analytical. Now, the focus of the framework of jurisdiction rules is what I'm going to move to, and particularly the role of forum conveniens in both service in and service out cases. And in this section, I'm going to focus on Spiliada being the key case, and then I'll look more briefly at two more recent cases. I'll look at Vedanta when I come to ground 1A. My lords, if I could ask you to turn up Spiliada, which is in the very start of the bundle of authorities, bundle 1, tab 1, at page 6. My lords, the evaluation of forum conveniens plays an important role in the exercise of the court's jurisdiction. But it's not the whole story. It's only part of the test. We're not at the point in the English courts of having just the forum conveniens test. There are other elements to the question of jurisdiction, and forum conveniens has a different role in the different contexts of service in and service out. Now, my lord, Spiliada is the central case on this topic still, and it's important to look at it in some detail. It's the classic statement of the doctrine of forum conveniens in English law. The English court, as your lordships will know, adopted it from Scots law. And if we turn that, first of all, the short judgment of Lord Templeman on page 10 of the bundle, Lord Templeman gives a focused and, in my submission, helpful summary of the overall position. And we can start page 10, just between G and H. Where the plaintiff is entitled to commence his action in this country, the court, applying the doctrine of forum non-conveniens, will only stay the action if the defendant satisfies the court that some other forum is more appropriate. Where the plaintiff can only commence his action with leave, the court applying the doctrine of forum conveniens will only grant leave if the plaintiff satisfies the court that England is the more appropriate forum to try the action, and then goes on to mention the second stage. Whatever reason may be advanced in favour of a forum, the plaintiff will be allowed to pursue an action which the English court has jurisdiction to entertain if it would be unjust for the plaintiff to confine him to remedies elsewhere. So in that paragraph, Lord Templeman is drawing the distinction between service in, where the claimant is entitled to commence the action in England, and service out. And the use of the word only in each of those sentences is important. Picking it up then between C and D on page 11, the factors which the court is entitled to take into account in considering whether one forum is more appropriate are legion. The authorities do not, perhaps cannot, give any clear guidance as to how these factors are to be weighed in any particular case. And then just at the end of that paragraph, the last sentence is important. Domicile and residence and place of incident are not always decisive. So it's clear they're important factors, although, of course, they're not always decisive. And then in the well-known passage from F, in the result, it seems to me the solution of disputes about the relative merits of trial in England and trial abroad is preeminently a matter for the trial judge. Commercial court judges are very experienced in these matters. I think that first sentence has been described as being the triumph of judicial hope over experience, perhaps for good reason. But the fact that commercial court judges are very experienced, well, that's obviously something we all know, and most of the cases, I think, on forum conveniens are in the commercial court, although obviously my Lord Neuberger makes a point of saying in VTB that chancery judges also are very adept at dealing
this is
with
neither.
conveniens. This is neither. My lords, turning then to Lord Gough's important judgment, look very briefly at the facts of the case and the issues before the court. So the case arose out of the transport of a cargo of sulphur from Vancouver to India. I'm on page 12, my lords. The cargo was shipped on the Spiliada, a vessel which flew the Liberian flag, and we can pick it up in the judgment of Lord Gough just below D. The appellants were the ship owners of the Spiliada. Liberian Corporation, although their managers are in Greece, although some part of the management takes place in England. The respondents, Cancellex, carry on business in British Columbia as exporters of sulphur. And so none of the parties in the Spiliada were in England. Leave to serve out was granted on the basis that there was a choice of law clause in the bills of lading, governed by English law. We see that between F and G. And the ship owners claimed damages from Cancellex for damage caused to their ship by the wet sulphur being loaded. And at 467, over the page 467C, we see that leave was obtained by the ship owners to issue and serve a writ upon Cancellex outside the jurisdiction on the basis that the contract was governed by English law. Council-X applied to set aside that leave. And then between D and F, on page 13, my lords, we see reference to the other set of proceedings which was going on at the same time, in which Council-X were also defendants, and they'd been served out on the same ground as in the Spiliada. The challenge in that case to jurisdiction was unsuccessful. And then 4.6, trial, my lord, was proceeding, the trial in the parallel case was proceeding in front of Miss Justice Staunton. And then at page 468, Lord Goff looks at the decision of Miss Justice Staunton in the Spiliada case. And just picking it up on page 15 of the bundle, 469 of the report, just to note the three elements that Miss Justice Staunton looked at in the Spiliada case. So between D and E, the judge then turned to consider the various factors which were said to influence the choice between an English and Canadian court. I need not list them all. The most important were availability of witnesses, multiplicity of proceedings, and a matter which was regarded as crucial by the judge, which I will call the Cambridgeshire factor, and which relates to preparation for various substantial proceedings. And that's where we get the start of the Cambridgeshire factor in form conveniens. My lord, I just highlight for your lordship's note that on 470, between C and E, the Lord Goff looks at the question of multiplicity of proceedings. I highlight that because it comes up again later on when we look at one of the subsequent authorities. So Council-X wished to join their insurers and possibly others as third parties, which they could only do in Canada. The shipowners wished to join MMTC as co-defendants. And then turning to the Cambridgeshire factor E, which he regarded as crucial, the judge had this to say. And then, my lords, if we can turn over to 471, decision of the Court of Appeal, just briefly. At the bottom of page 17 of the bundle, just after G, looking at the judgment of Lord Justice Neil, with regard to the availability of witnesses, he felt that even on the judge's own analysis, the convenience of the parties probably tilted the scales towards British Columbia, but certainly did not show an English court was distinctly more suitable. On multiplicity of proceedings, he saw force in the criticism of Mr. Goldsmith. It was at most a neutral factor. On the relevance of the Cambridgeshire factor, he considered the judge had attached far too much importance to it. And then picking up further down that page, 472, 18 in the bundle, just below C, Oliver, like Lord Justice Neil, accepted they were bound to follow the Court of Appeal in Elysia. And then just below D, he considered the exercise of the judge's discretion. He reviewed the judge's assessment of the availability of witnesses in considerable detail. And then just below E, in his opinion, the highest that could be put on the shipowner's side was that the factor of convenience of witnesses was neutral. He considered the point of multiplicity and rejected criticism of the judge's approach because it was neutral. Turning to the Cambridgeshire factor, he was very critical of the judge's approach. And my lord, we'll come back to Lord Goff's conclusions on those 3 points after we look at the key principles. And in terms of the key principles, if I could direct your lordship's attention to page 19 of the bundle, 473 of the report, down at the bottom, just at letter H. It's in the section headed Submissions of Counsel, but in fact at the end of this, Lord Goff starts his judgment. We'll read from there, but in any event, the law on this subject is still in a state of development, and it's perhaps opportune to review the position at this stage, and in particular to give further consideration to the relationship between cases where jurisdiction has been founded as of right by service of proceedings on the defendant within the jurisdiction, but the defendant seeks to stay on the ground and form non-conveniens, and cases where the court is invited to exercise its discretion to give leave for service out of the jurisdiction. And then the fundamental principle, and I'll take the lordships through this quite quickly because I know it will be very familiar to you, but in my submission it's important to get the framework right. So the fundamental principle, in cases where jurisdiction has been founded as of right, the defendant has been served with the proceedings, the defendant may now apply to the court to exercise its discretion to stay the proceedings on form non-conveniens. And little c, English law and Scots law may now be regarded as indistinguishable. It's proper, therefore, to regard the classic statement of Lord Kinnear as expressing the principle now applicable in both jurisdictions. The plea can never be sustained unless the court is satisfied that there is some other tribunal having competent jurisdiction in which the case may be tried more suitably for the interests of all the parties and for the ends of justice. And I do highlight and emphasise the word more. And then from E to G, Lord Gough discusses the Latin tag forum non conveniens and whether the terminology is as good as it could be, because he says the question is not one of convenience, but of suitability. He says that just below E, but he concludes that it's so widely used, the term, that it's probably sensible to retain it, but, and this is important, it's most important not to allow it to mislead us into thinking that the question at issue is one of mere practical convenience. And one of our submissions is that the judge focused very much on practical convenience and did not take into account the other aspects of the forum conveniens evaluation. And my lord, then turning over to, I think just picking it up at the bottom of 474, below H, Lord Sumner referred to a phrase used by Lord Cowan, more convenient and preferable for securing the ends of justice. And then the quote on the next page, one cannot think of convenience apart from the convenience of the pursuer or the defender or the court. And the convenience of all of these three, as the case shows, of little, if any, importance. If you read it as more convenient, that's to say preferable for securing the ends of justice, I think the true meaning of the doctrine is arrived at. The object is to find that form which is more suitable for the ends of justice and is preferable because pursuit of the litigation in that form is more likely to secure those ends. And then Lord Gough's conclusion, in the light of these authoritative statements of the Scottish doctrine, I cannot help thinking it's wiser to avoid the use of convenience and refer to it as appropriate forum. And we say that is the correct terminology. And then Lord Gough goes on to consider how the principle is applied in cases of an application for a stay, where there's service in. The stay in those cases will only be granted if the court is satisfied. Pick that up at page 476, 22 of the bundle at C. Summary of the law on applications by defendants for stays on the basis of forum non-convenience. So little a will only be granted if the court is satisfied that the appropriate forum, i.e. in which the case may be tried more suitably. So he picks up the wording from the previous quote. And there's two elements, obviously, to it. The defendant needs to satisfy the court there is an available other forum, and secondly, that forum is the appropriate forum for the trial of the action. And if the defendant does not establish both of those, the application fails, and that is the end of the consideration. Second point at little b, as to the burden of proof. So as Lord Kinnear's formulation indicates, in general, the burden of proof rests on the defendant to persuade the court to exercise its discretion to grant a stay. And then Lord Gough notes that obviously if there's individual facts that need to be established, that's for each of the parties. And then little c at F, the question being whether there is some other form which is the appropriate form, it's pertinent to ask whether the fact that the plaintiff has found a jurisdiction as of right of itself gives the plaintiff an advantage. And Lord Gough looks at the US jurisprudence on that. But we can turn now to 477 at little c, picking it up at little c on this point. Lord Gough says there's cases where no particular form can be described as the natural form, might occur in commercial disputes. And then at little d, I can see no reason why the English court should not refuse to grant a stay in such a case where jurisdiction has been founded as of right. It is significant that in all leading English cases where a stay has been granted, there's been another clearly more appropriate forum. And then an important passage just at E. In my opinion, the burden resting on the defendant is not just assuring England is not the natural or appropriate forum, but to establish that there is another available form which is clearly or distinctly more appropriate. In this way, proper regard is paid to the fact that jurisdiction has been founded in England as of right. And he goes on to say the further advantage that there will then be a broad consensus among major common law jurisdictions. And then Lord Gough continues, I may add that if in any case the connection of the defendant with the English form is a fragile one, for example, he's served with proceedings during a short visit to this country, it should be all the easier for him to prove there is clearly another clearly more appropriate forum for the trial overseas. And so the fact that service as of right is affected is reflected in the burden being on the defendant, but also the burden being a significant hurdle that the defendant has to show it's clearly and distinctly more appropriate. So it's not a question of everything being evenly balanced when we're looking at the first and second defendants who have been served as of right. The burden is very clearly on the defendant, and the starting point is the court does have jurisdiction by virtue of the service. The court's got jurisdiction, the defendant's got to persuade the court not to exercise that jurisdiction. And then little d, Lord Gough, so page 23 of the bundle, Lord Gough looks at the factors. Since the question is whether there exists some other form which is clearly more appropriate, the court will look first to see what factors there are which point in the direction of another forum. These are the factors. Lord Gough, a few lines from the bottom, says, I respectfully consider it may be more desirable to adopt the expression used by Lord Keith when he referred to the natural forum as that being that with which the action has the most real and substantial connection. And that's become the key test. Does the forum have the most real and substantial connection? So it's for connecting factors in this sense the court must first look. These will include not only factors affecting convenience or expense, but also other factors such as the law governing the relevant transaction and the places where parties respectively reside or carry on business. And that's the difference, we say, between the summary given by Lord Briggs, which the judge uses, and Lord Gough's list. Again, it's a list that is only phrased as being including these factors, but it includes the connections of the parties, whereas Lord Briggs's list doesn't. And then the fifth point, little e, if the court concludes there is no other available form which is clearly more appropriate, it will ordinarily refuse a stay. And the sixth and final, if, however, the court concludes there is some other available forum, it will ordinarily grant a stay unless there are circumstances by reason of justice which requires that a stay should not be granted. In this inquiry, the court will consider all the circumstances of the case. So that's beyond just connecting factors. And that test, we know then, was clarified by Lord Collins in Ultimo, that the claimant needs to establish a real risk that justice will not be obtained. So moving on then to look at the approach so that's the approach to the first and second defendant's application we say that the judge should have taken. Lord Gough then just turns his attention to the principles to be applied where the court exercises its power to grant leave to serve out, in contrast. So picking that up just between E and F, how the principles applied, and Lord Gough refers to Lord Diplock in Amin Rashid, the jurisdiction exercised by an English court over a foreign corporation which has no place of business in this country is one which under general English conflict is an exorbitant jurisdiction, he says, i.e. one which under general conflict rules an English court would not recognise as possessed by a foreign court. Comity thus dictates that judicial discretion to grant leave should be exercised with circumspection in cases where there exists an alternative forum. And we know that in this case, obviously the claimants had to obtain permission to serve out on the third defendant. The current rules are in part 6 of the CPR. There's 3 elements to the grounds. There needs to be a ground for jurisdiction. The claimants need to satisfy the merits test. There needs to be real prospects of success against that defendant. And thirdly, forum conveniens, that the English court is the proper place for the trial of the action. So forum convenience is one element in a three-part test that the claimant has to satisfy. I think we can pick it up at 480G in Lord Goff's judgment. So just above G, Lord Goff says, it seems to be inevitable that the question in both groups of cases, so it's service in, service out, must be at bottom that expressed by Lord Kinnear in Sim and Robinau, to identify the form in which the case can be suitably tried for the interests of all the parties and for the ends of justice. That being said, it's desirable to identify the distinctions between the two groups of cases, and these, he says, are threefold. The first is that in the Order 11 cases, so that's service out, the burden of proof rests on the plaintiff, whereas in the forum non-convenience case, the burden rests on the defendant. The second, more fundamental point of distinction, but from which the burden of proof flows, is what Lord Goff says, is that in Order 11 cases, the plaintiff is seeking to persuade the court to exercise its discretionary power to permit service out of the jurisdiction. Statutory authority has specified the particular circumstances in which that power may be exercised, but leaves it to the court to decide whether to exercise its discretionary power, provided that leave shall not be granted unless it shall be made sufficiently to appear to the court that the case is a proper one for service act. And that's now reflected in CPR 636 and 37, those three elements. The statutory authority is now the practice direction. Practice direction 6B specifies the grounds on which the court has power to grant permission to serve out. And then, my Lord, the third distinction that Lord Goff highlights, little b on page 27 of the bundle. So at this point, special regard must be had for the fact stressed by Lord Dibclock that the jurisdiction exercised under Order 11 may be exorbitant. And he looks at some older cases on that. And if we pick it up just below D, the effect is not merely that the burden of proof rests on the claimant to persuade the court that England is the appropriate forum for the trial, but that he has to show that this is clearly so. In other words, the burden is quite simply the obverse of that applicable, whereas stay is sort of proceeding started in this country as of right. And we say that's very important because it's not that it's simply a level playing field. And that's why it's important that the approach does look individually at the separate defendants and the nature of the applications, because the burden of proof is there to reflect the difference in the role of forum convenience, but also the starting point for the court's jurisdiction. My Lords, Lord Goff then looks briefly at the question of exorbitance, and just picking it up to the end, just below G, another couple of points here. In addition, he says the importance to be attached to any particular ground, that's ground for jurisdiction invoked by the plaintiff, may vary from case to case. For example, the fact that English law is the proper law of the contract may be of great importance, a few lines down, or it may be of little importance as seen in the context of the whole case. In these circumstances, it is, in my judgment, necessary to include both the residence or place of business of the defendant and the relevant ground invoked by the plaintiff as factors to be considered by the court when deciding whether to exercise its discretion. But in doing so, the court should give to such factors the weight which, in all the circumstances of the case, it considers to be appropriate. So, my Lord, can I just summarise the propositions we take from Spiliada? There's 5 points. First of all, that the focus in both service in and service out cases is on identifying the appropriate forum. Secondly, that the test in both cases, the appropriate forum is the forum in which the case may be tried more suitably for the interests of all the parties and the end of justice. And it's the forum with which the action has the most real and substantial connection. There's 2 parts to that. Thirdly, to apply the test, the court identifies and evaluates the connecting factors, and the weight to be given to those factors varies depending on all the circumstances of the case. Fourthly, in terms of proof, first of all, the burden of proof on forum convenience is on the defendant for service in and on the claimant for service out. The standard of proof is significant, is clearly and distinctly more appropriate, and it's the same standard for both, but reversed in terms of burden of proof. And that is intended to reflect the fact that in the two categories of cases, the starting point regarding jurisdiction is different. And that's picked up again by Lord Manson, VTB, just for your Lordship's note. Paragraph 12, he refers to Lord Gough having identified the important distinction in the starting point and the onus of proof. And fifthly, and finally, the role of forum convenience and the time at which it arises for consideration are distinct in the two cases. In service in, forum non-conveniens arises in the context of the court's jurisdiction already being established. So the court has jurisdiction and then it thinks about forum conveniens. So forum non-conveniens in a sense operates to restrict the claims over which the court takes jurisdiction. For service out cases, forum conveniens is only one element of three which the claimant needs to establish positively in order to be allowed to serve out. A jurisdictional ground, CPR 637(1)A, the merits, reasonable prospects of success, 637(1)B, and proper place, forum conveniens 637(3). The court will not give permission unless satisfied that England is the proper place. And my Lord, just to finish on Spiliada, 4.6. Yes, we noted at 469D the three important factors that the judge at first instance, Mr. Justice Staunton, was looking at: availability of witnesses, multiplicity of proceedings, and Cambridgeshire factor. And at 484E, we see that Lord Gough applies the principles he's just set out to the facts of this case. 480F, he says he doesn't think there's any, unable to accept the submission that the judge made any material error of principle. And then 485, C to E, that's on page 31 of the bundle. Turning to the factor of multiplicity of proceedings, the judge referred to the possibility of other defendants being added. But once again, the judge did not have to decide and did not decide this particular factor was decisive of the case. The judge gave the weight to his factor. He was, in my judgment, entitled to do so. And then just between E and F, the crucial point in the judge's view was the Cambridgeshire factor. This was regarded by Lord Justice Neave as relevant, and in this I found myself to be in agreement. The criticism of the judge's view goes to its weight. With all respect, however, when I read the judgments of both Lord Justices and the Court of Appeal, I consider they underrated it, and then sets out why he thinks it's important. And then just on 486, 32 of the bundle, just at C, for these reasons are there, and I am of the opinion this is a classic example where the appellate court has simply formed a different view. But in addition, there are two other factors which the judge could but did not take into account in support of the conclusion he in fact reached. And I draw your Lordship's attention to the first of these. He was, in my judgment, entitled to take into account in assessing the Cambridgeshire factor the fact that although the owners in the two cases were different, the solicitors for the owners were in both cases instructed by the same insurers, and he was entitled to take into account that the insurers of the shipowners in the present case are managed in England. Usually that doesn't matter, he says, but in a case of an application such as that in the present, it's shutting one's eyes to reality to ignore the fact that it's the insurers who are financing the litigation and our dominus litis, and this, in my view, is a relevant factor. And we say that comes into our ground 1E, about the conduct of the litigation. The conduct of the litigation is centred in England, and we say that's an important factor relying on that.
Conduct of which litigation? Is your Cambridgeshire factor point?
So there's the Cambridgeshire factor point.
The conduct of the defamation proceedings.
There's the Cambridgeshire factor point about the conduct of the libel proceedings, but we had a separate point at first instance, and is the subject of our ground 1E, which we say the judge didn't take into account at all, which is that the conduct of litigation arising from these claims, whether they're in England or in Malaysia, will be managed in England.
And that includes, as I understand it, the suggestion that the claim against D3 will also be managed from England.
Absolutely, that is the...
I hadn't, for my part, take it whenever you will, understood where the evidence was that supported that, but you'll come to that.
I'll come to that, thank you, my lord, when I come to ground 1E. The point about that really is just that Lord Gough is saying in Spiliada that the insurers effectively are controlling the litigation. It's the nerve centre of the litigation. We say it's the same in this case, not insurers, but the English base is, and that's relevant. My lord, I'd like to take your lordships to two other cases very briefly on the principles before then I move to look at the grounds of appeal. The first is the decision of the Supreme Court in FS Carr and Brownlee, which is in the Third Authorities bundle at tab 28, at page 979. My lords, the appeal to the Supreme Court in this case, which became Brownlee 2 in the Supreme Court, was on 2 points: the scope of the tort gateway and the proof of foreign law and the presumption. But Lord Lloyd Jones, giving judgment for the majority, does comment in some detail on foreign convenience, and it's that point I want to take the lordships.
I'd just like to congratulate your solicitors, or both solicitors, on, for the first time since I've been using digital bundles, which is about 5 years, the page numbers in the authorities bundle coincide with the paper, and that saves a massive amount of time for two of their lordships here today. So thank you.
My lord, I'm sure they'll be very grateful for those thanks. It's not often they are thanked, but we're glad that the bundles are working. Well,
I mean, I reckon we've saved 10 minutes. I mean, I'm now going on and wasting time, but I think we've saved 10 minutes in your going through the Spiliada, and now we will with Brownlee, because we can see which page you're on.
It works. Good. Well, we're very pleased to hear it works, my lord.
Good. Off you go.
So, looking at the judgment of Lord Lloyd Jones, as I say, we don't need to look at the specific issues that were before the court, but you'll see at paragraph 28 of the Lord Jones's judgment, so page 991 of the bundle, he starts issue 1, the tort gateway, and he says in this case we're looking at the domestic rules, so it's not a Brussels regulation case, but we're looking at the scope of the tort gateway. And at the end of 28, looks at foreign non-convenience. This requirement is reflected in CPR 637. The applicable principles are stated by Lord Gough in Spiliada. So we know it's still good law. And then turning over to paragraph 30, Lord Lloyd Jones helpfully sets out there CPR 636 and 37, which I was referring to, but I didn't take your lordships to. And then the claims in tort gateway, just worth looking at briefly, because of what I'll come back to. So the ground for jurisdiction for claims in tort at the moment in the CPR, service out may be permitted where a claim is made in tort where A, damage was sustained or will be sustained within the jurisdiction, and that was the focus of the Supreme Court's decision. What does damage mean in that context? But little b, damage which has been or will be sustained results from an act committed or likely to be committed within the jurisdiction. So the CPR highlights those as being significant grounds for jurisdiction in a tort claim. Lord Lloyd Jones says, in the present case, the issue is whether it's damage, it's common ground between the parties that B cannot apply as the relevant act. The act committed occurred entirely in Egypt and not in England, so it was a road traffic accident, all in one jurisdiction. We say, in this case, obviously there were acts in England. We don't need this ground for the first and second defendant, but I'm just highlighting that they're relevant connecting factors in tort claims. My lords, Lord Lloyd Jones sets out from paragraph 35 onward the history of the tort gateway, which you don't need to look at. And then we can pick it up at paragraph 77, which is on page 1008
So just to go back to your last point.
Yes.
Have I understood correctly that this wasn't in fact a gateway it was relied on so far as the third defendant?
That's right. It's only the necessary and proper party gateway, and we say that gives rise to specific issues in the context of forum conveniens, but this was not relied on. All I'm doing is pointing out that in general conflicts terms, it's thought to be not just damage that's relevant to tort in terms of connecting factors, but also where the act was committed. That grounds jurisdiction for the English court in tort claims, or can do. It doesn't in this case. Well, I was taking it up then at paragraph 77 of Lord Lloyd Jones' judgment, so under discretion. There was arguments in Brownlee as to whether a wide reading of damage in the ground would be problematic, because the English court then would be taking jurisdiction over all sorts of things that had happened abroad. But not so, says Lord Lloyd Jones, just at H. This, however, overlooks the fact that jurisdictional gateways in the practice direction, however wide or narrow, form only one element of the jurisdictional test. Before the court will give permission to serve out, not only must a claim pass through one of the gateways, it must also be shown that England is the proper place in which to bring the claim. I'm unable to agree with the statement of Lord Sumption in Brownlee 1, that the discretion as to forum non-conveniens authorises the court to decline a jurisdiction which possesses a matter of law. It does when it's service in, but we're talking about service out here. The gateways alone do not confer jurisdiction, and the discretionary test must be satisfied before permission to serve out will be given. Provided that the discretionary test is correctly applied, there should therefore be no danger that the wider reading of damage would establish a jurisdiction simply on the basis of the English identity of the claimant, or that it would permit foreign defendants to be brought before the English court in cases where there is no substantial connection between the wrongdoing and the jurisdiction. I do highlight that as being, forum conveniens focuses on those connections between the wrongdoing and the jurisdiction. And then in 78, an important point, we can pick it up just the second sentence, 3 lines down.
I'm so sorry, which paragraph?
I'm so sorry, 78. Lord Lloyd Jones refers to Lord Sumption in Brownlee 1, saying the main determining factor in forum conveniens is not the relationship between the cause of action in England, but the practicalities of litigation. Says, while it's correct that practical issues can feature large in the exercise of the discretion is not so limited. And then he refers to Lord Wilson. Now, if we pick it up just below the quotes, so just below G, in applying the principle, the ultimate objective is to identify the forum, and quotes Lord Gough. And then 79, the discretionary test of forum non-conveniens, well established in our law, is an appropriate and effective mechanism which can be trusted to prevent the acceptance of jurisdiction in situations where there is merely a casual or adventitious link between the claim and England. Where a claim passes through a qualifying gateway, there remains a burden on the claimant to persuade the court that England and Wales is the proper place. Unless that is established, permission to serve out will be refused. In addition, and this is a point to which I attach particular importance, and as do I in the context of this case, the forum non-conveniens principle is not a mere general discretion, the application of which may vary according to the differing subjective views of different judges, creating a danger of legal uncertainty. On the contrary, the principle applies a structured discretion, the details of which have been refined in the decided cases in a readily predictable manner. And we say that structured discretion also goes across the jurisdiction rules. It's supposed to be approached on a structured basis. And because of the different starting points, the different burdens of proof, the fact that it's not a level playing field with the burden, it does need to be approached in a structured way. My Lords, the second case I want to take your Lordships to is the Court of Appeal judgment in Samsung, which this may be where the page numbers go wrong, my Lord, I hope not, but they're in the New Authorities volume, oh no, maybe not. I'm getting ahead of myself. So volume 3, tab 29. So the page number should be fine. This was a judgment of the Court of Appeal in Samsung Electronics and LG Display, page 1047 of the bundle. And I just want to highlight 3 points of principle in the judgment of Lord Justice Mayles. It was an appeal by the claimants from a decision that England was not the appropriate forum for the trial of its contribution claims. It was the primary case, or the underlying case had been settled, and then a new, fresh contribution claim had been started. And the question was, did the English court have jurisdiction over the contribution claim? And it was a service out. It was a service out case. And so, just turning then to the judgment of Justice Mayers at 1049. First, I invite your Lordship's attention to paragraphs 2 and 3 on the standard of proof on the issue of form convenience. It's generally the case when an issue about appropriate form arises, there'll be a range of factors to be considered, some of which will point in favour of English jurisdiction, others will be neutral or will point to the appropriateness of proceedings elsewhere. It's for the parties to identify the connecting factors on which they rely. It's then for the judge to decide how much weight to give the various factors and decide where the balance lies. The test to be applied is proper place, and he refers to Spiliada and BTB. This means that the burden is on the claimant to satisfy the court that England's clearly the appropriate form for the claim. And then 3, accordingly, it's not enough that the issue is finely balanced, or even that proceedings in England are marginally more appropriate than proceedings elsewhere. England must be clearly the appropriate form. So that's for service out. And we saw in Spiliada that the burdens are simply the obverse. So for the claim against the English defendants, we say the English defendants have to show not just that it's marginally more appropriate for proceedings elsewhere, but that Malaysia is clearly and distinctly the more appropriate form. So it's a significant hurdle, unsurprisingly, given that the starting point is that the court has jurisdiction on the basis of service in. Secondly, there's a convenient reminder of the approach on appeal in relation to form convenience on 4. Often the question whether the test is satisfied will not have a single right answer. Views may reasonably differ as to the weight to be attributed to the different connecting factors. The fact that this court might or even would have reached a different conclusion is not itself a reason to allow an appeal. Rather, this court may only interfere if the judge has made a significant error of principle or a significant error in the consideration taken or not taken into account. And we rely on that, and we say the judge has made significant errors of principle and has made significant errors in the considerations he did not take into account in particular. And thirdly, paragraph 5, very useful 3 paragraphs, and is important in the context of the moving picture in this case in our submission. And Justice Mayer says it's important to say the function of this court.
Where are you?
Oh, I'm sorry, my lord. Page 1050, paragraph 5. It's important to say the function of this court, the Court of Appeal, is to review the decision of the court below. The question is whether the judge has made a significant error having regard to the evidence adduced and the submissions advanced in the lower court. Just as the trial of an action is not a dress rehearsal for an appeal, in the well-known metaphor, neither is an application to set aside an order for service out of the jurisdiction. In general, an appellant, we would say also a respondent, will not be permitted to rely on material which the judge was not invited to consider, or to advance an entirely new basis for saying the judge's evaluation was wrong. The judge can hardly be criticised for not taking something into account it was never asked to do so. Although no doubt this principle will be applied with some flexibility, bearing in mind that the ultimate Spiliada question is concerned with the interests of all the parties and the ends of justice. Good reason will be required for taking a different approach. And as I say, I draw that to your Lordship's attention in the context of the moving picture, particularly on the libel proceedings. My Lords, I think, got to the end of my overall legal framework, and I was going to move to the grounds of appeal.
As you go through these grounds of appeal, could you identify for me the significant errors of principle that you say the judge made as you come to them?
I will do. My Lord, just to summarise our grounds of appeal, we've got 5 grounds of appeal. The first one, little a, we say has 2 connected elements. So first of all, that the judge was wrong in his overall approach to the applications, and secondly, that he failed to take into account properly or at all the strong connections which the first and second defendants in particular have with England. Little b, we say he failed to have any proper regard to other key connecting factors in favour of England, in particular the location of the relevant wrongdoing. Little c, as regards applicable law, we say his analysis was incorrect as a matter of law. Little d, the libel proceedings, we say he misdirected himself in relation to the risk of inconsistent judgments and failed to give sufficient weight to that factor. And little e, the place of the conduct of the defence, he effectively ignored. So ground 1A, as I say, two distinct but related points in this ground. And the issues which arise, particularly on the first part of this ground, are fundamental to the whole appeal. Now, as we submit that the correct approach to the first and second defendant's application on the one hand and the third defendant's is as per Spiliada. And that by addressing the applications separately and sequentially, that ensures that the court's focus is correct at each stage. The judge did not approach the applications separately, and we say that led him into error. We'll look again now at the key paragraphs of the judgment. In other words, it's in...
The heart of this submission is not just separately and sequentially, but look at the stay application first.
Absolutely.
If one did it the other way round, then...
It would make no sense to do it the other way round.
Well, you say it would make no sense, but if you did it the other way round, you wouldn't get the result for which you contend.
Well, you wouldn't, but I say it wouldn't make sense, particularly in the context of the fact that the third defendant's, the ground for jurisdiction is the necessary and proper party gateway. If there was a different ground for jurisdiction, you could do the third defendant first, because you could look at that ground. But in the context where the ground that we rely on is necessary and proper party, it needs something to hook onto. So if there is no underlying sort of anchor, as it's sometimes called, that doesn't. So we say it particularly doesn't make sense in that context to do D3 before D1 and 2. You could, but you would have to make a lot of assumptions in that context. So it makes more sense, certainly, to do D1, D2, and then D3. And then just looking then again at the judgment in a little bit more detail, and then we'll look at Vedanta. So the key paragraphs of the judgment for this ground of appeal, we say, are 122 to 123, so the conclusions, and 30 and 37. And as I highlighted to your lordships earlier, in both 30 and 37, the judge refers to the judgment of Lord Briggs and Vedanta, and refers to the case involving a mix of service in and service out. My learned friend's appeal skeleton is worth just turning up briefly. It's in the core bundle, tab 2 of the core bundle, paragraphs 7 to 9. So it's page 32 of the core bundle. My lords, the respondents say the judge correctly directed himself as to the law applicable. The judge identified that this was a mixed case, in inverted commas, with applications made by both English and foreign domiciled defendants. In accordance with the dicta of Lord Briggs, he noted the court is looking for the jurisdiction in which the claims against all the defendants can most suitably be tried. And then going down to paragraph 9, the judge did take account of the claimant's submissions that the domicile means stood as of right. As noted above, however, the judge was applying the mixed case test, which takes into account, when looking for the single jurisdiction, the domicile of the English defendants and the foreign defendants. My lords, in our submission, there is no special test for mixed cases. We say that Vedanta does not require the court to apply a new or a different test. Spiliada is still the test, albeit that obviously it's important to look at the case as a whole, but you have to look, first of all, at the detail. So, my lords, if I could take your lordships to Vedanta, it's in Authorities Bundle 2, at tab 23, at page 824. My Lords, Vedanta was a very different case from this, both factually and legally. The case arose in the very specific legal framework of the interplay between the Brussels regulation and the English domestic rules for jurisdiction. It's the old regime, and it does not apply in this case and can no longer arise. My Lord, the facts are set out in the judgment of Lord Briggs, paragraphs 1 to 2. But in summary, it was a claim brought by over 1,800 Zambian citizens who lived in 4 communities in Zambia. The claim was based on the fact that the claimant's health and farming activities had been damaged by discharges of toxic waste from the copper mine into the watercourses, which were their only source of water for drinking and for their crops. A claim was brought against the owner of the mine as the second defendant, Concola Copper Mines, a Zambian company who employed 16,000 people mainly at the mine, and the claim was also brought against the first defendant, Vedanta Resources plc, a UK incorporated company, but which only had 19 employees, including all its directors. It was effectively a parent company of the multinational group, and it was the ultimate parent company of KCM. And the claim that was brought against Vedanta Resources was based on a high level of control and direction by Vedanta, and equivalent effectively to KCM being wholly owned by Vedanta. There was a jurisdiction challenge by both defendants. We can pick it up in the judgment of Lord Briggs at 15. He says, although technically there are 2 appeals, one by each of the defendants, they're closely interrelated, and the proceedings before this court are best understood as a single appeal. And then at 16, jurisdiction against the anchor defendant derives directly from Article 4 of the Brussels Recast Regulation. So it was governed by the Brussels Regulation, domicile, Article 4, so there was jurisdiction. And as Lord Briggs points out in that paragraph, that means Owusu and Jackson precluded the court from declining to take jurisdiction on the basis of form convenience. And then 17, the jurisdiction against the second defendant, who was domiciled in Zambia, was based on the necessary or proper party gateway. But 17 is worth just looking at. 3 lines down, Vedanta has not pursued a strikeout or summary judgment application against itself, but both it and KCM assert that the claimant's pleaded case and supporting evidence disclose no real triable issue against Vedanta, because Vedanta cannot be shown to have done anything. And so that arose in the context of the necessary and proper party gateway. Was there a real issue against D1? And that's why I said at the beginning, in this case, it's important to note that in this case, no such point is taken on the merits against either of the defendants, and the appeal in the Supreme Court was partly focused on the merits, this common ground merits between the 2 defendants. Secondly, picking up to 18, the second of Vedanta's submissions, Vedanta maintains even if the pleaded claim discloses a tribal issue against it, nonetheless the claim should be stayed as an abuse of EU law, because the claimants are using the claim purely against Vedanta purely to attract jurisdiction against their real target defendant. And then 20 just notes the necessary and proper party gateway, and then picking it up at 21, as I already noted, the question whether the claims disclose a real tribal issue against Vedanta is a main issue on this appeal. It's however accepted if the claimants surmount the hurdle, it would be reasonable for the court to try that issue, and that KCM would be at least a proper party. And it's now common ground that claims against KCM have a real prospect of success. And then 22, the judge in the Court of Appeal found in the claimant's favour on real issue and proper place. In addition, he found that even if Zambia would otherwise have been the proper place, there was a real risk the claimants would not obtain justice. And so the issues will be addressed in the following order: abuse of EU law, real issue against Vedanta, proper place, and substantial justice. And so, despite very creative arguments by Mr. Gibson and his team in Vedanta, including that there was an abuse of EU law by suing Vedanta, the Supreme Court confirmed there was no scope for the English court to stay the proceedings against the English-domiciled defendant on the basis of form non-convenience. And if I could take your lordship to Lord Briggs's judgment, first of all on abuse of EU law. 29 says he's satisfied to the point of Act Clare that the EU principle of abuse does not avail the defendants. And then picking it up at 36, just to see what the complaint was. The complaint is that Article 4 has been used as a means of circumventing or misusing the English national regime. Then 37, this complaint forms a central theme in the defendant's submissions about abuse of EU law and the necessary and proper party gateway. And then 39, they now I think quite well-known words of Lord Briggs. Following Owusu, the English court has one hand tied behind its back. No more can it stay the proceedings against the anchor defendant. That's the precise ratio of Owusu. The result is, in a case such as the present, where the English court are persuaded that whatever happens to the claim against the foreign defendants, the claimants will continue in England against the anchor defendant, the risk of irreconcilable judgments becomes a formidable, often insuperable obstacle to the identification of any jurisdiction other than England as the form convenience. He highlights that that's become an issue in environmental group claims. And then turning over to the end of paragraph 40, so he's identified that's the problem, that you can't stay the proceedings against the anchor defendant, and so then it's being argued that necessarily the court should take jurisdiction against the second defendant. But turning over, picking it up at C on 843, or just above C, in my view, if there's a remedy for this undoubted problem, it lies in an appropriate adjustment of the English form convenience jurisprudence, not so as to permit the English court to stay the proceedings against the anchor defendant if genuinely pursued, but rather to temper the rigour of the need to avoid irreconcilable judgments, which has thus far served to disable the English court from concluding that any jurisdiction other than its own is the form convenience for the litigation of the claim against the foreign defendant. And I do highlight that. Because obviously there wasn't scope for the court to decide on the question of form convenience vis-a-vis Vedanta. And we can then move on to paragraph 66, because in the intervening paragraphs the court is looking at the real issue, the question of the real issue. Is there a real issue against Vedanta, the parent company question? And picking it up at 66, page 849, so here, this is where Lord Briggs goes on to look at, as he says in the title, is England the proper place in which to bring the claim against KCM, so against the second defendant? I found this to be the most difficult issue in this appeal. It raises an important issue of law and sets out the necessary and proper party. And then he refers at 850 to the Spiliada and Ultimo. And then we see the section from that concept down to the end of that paragraph, which is the paragraph quoted by the judge in paragraph 30. So a summary examination of connecting factors, those include, and including the various factors. Although they're not important, they're not necessarily conclusive. Lord Briggs says connecting factors also include matters such as system of law and things. So that's the whole quote that the judge has in 30. And then in 67, he identifies why the problem on this appeal in Vedanta arises. And he says it's a combination of two factors. So 3 lines down, the problems thrown up by this appeal all arise from a combination of 2 factors. The first is that the case involves multiple defendants. So that's easy. But the second is that following Owusu and Jackson, the court is disabled from the exercise of its common law power to stay proceedings. So it's the combination of those 2 factors that make up the critical context for the Supreme Court's decision in Vedanta. And we say, obviously, in this case, the second factor doesn't come into play because the court can stay its proceedings against the first defendant. But that's the problem that Lord Briggs is addressing. And then looking into 68, there's no doubt when Lord Gough originally formulated the concept which the case can suitably be tried, he was referring to the case as a whole, and therefore as including the anchor defendant. Well, we agree he was referring to the case as a whole. In fact, in Spiriada, I was showing you about the multiplicity of proceedings because at that point there was only a single defendant and single claimant. It was just there was prospective other claims to be joined, but at that point there was only two parties. But we absolutely accept that he was talking about the case as a whole. And then picking it up further down in 68, so Lord Briggs says, the concept behind the phrase is the form and the proper place is the court is looking for a single jurisdiction in which the claims against all the defendants may most suitably be tried. And that's the source of the quote in the judgment at paragraph 30. So where the judge says the instant case involves a mix of service in and service out. In these circumstances, the court is looking for a single jurisdiction in which the claims can most, against all defendants may most suitably be tried. And then moving on then to 69, Lord Briggs says an unspoken assumption behind the formulation of the concept of foreign convenience may have been prior to a jurisdiction in which the claim simply could not be tried against some of the defendants, could not qualify as a proper place, because the consequence of trial there against some of the defendants was risk multiplicity of proceedings about the same issues and inconsistent judgments. But the cases in which this risk has been expressly addressed tend to show it is only one factor, albeit a very important factor indeed, in the evaluative task of identifying the proper place. For example, he refers to the ERAS elections. Lord Justice Mustard said, in practice, the factors which make the party served a necessary party would also weigh heavily in favour of granting leave to make the foreigner a party, although they will not be conclusive. My Lords, we say that the effect of 68 read with 69 is that in applying Spiriada in a case where there are multiple defendants, ideally the court is looking for a single jurisdiction. And without doubt, the court needs to stand back and look at the case as a whole. But there is no support for there being a separate new test which applies in such cases. And so we say it's possible that the court could conclude that the English defendants have not discharged their burden, and so the claim proceeds against the English defendants in this jurisdiction, but doesn't take jurisdiction over the third defendant, because albeit that the risk of inconsistent judgments is a really important factor, it's not a trump card as we've come to see.
Do you say the judge applied a separate new test? And if so, which?
Well, we do say that, and I think that's why I took your lordships to my learned friend's skeleton, because the judge recites the passages from Vedanta, and I took the lordships to paragraph 2 at the start of his judgment. We say he just looked at the position overall and thought he had to find a single jurisdiction. And that's why I highlighted also that when he's looking at multiplicity of proceedings, he doesn't look at the question of the claim proceeding against D1 and D2 and then the impact that might have on D3 and the case law. Your lordships are aware there's quite a lot of case law on that, including Vedanta, obviously, but it's not the whole story. And we say he did effectively just take a single decision. He was trying to find the forum for the case as a whole, and albeit that is ideally what the court should do, if the court approaches the applications separately and sequentially, yes, the risk of inconsistent proceedings becomes an important factor, but it's not elevated to being the key factor that the judge appears to have made it. So we do say that in 69, Lord Briggs is at pains to emphasise that the risk of multiplicity of proceedings is only one factor, albeit a very important factor. And I'll take your lordships briefly later on to the case of ED and F-Man decision of this court, which my Lord Justice Voss was in, where the judgment of the court emphasises that this is the general principle to be derived from Vedanta. My Lord, in 70, Lord Briggs then goes on to consider cases where the fact that the claim is continuing against the anchor defendant has been treated as being decisive. in terms of the forum convenience against the other defendant, even where all other connecting factors favoured another jurisdiction. And he refers there to the decision of Mr. Justice Leggett, as he then was in BTB Bank and Parleen. At 72, Lord Briggs is looking at the analysis of Mr. Justice Coulson at first instance, and he says it's obvious from his analysis that had the English court retained its jurisdiction to stay proceedings against Vedanta as it was thought it did prior to it, so the judge would have done so, and thereby ensured that the case was brought to trial against both defendants in Zambia. And so we do say that it's very important to note the specific circumstances under consideration by the Supreme Court in Vedanta. The question of forum convenience against D1 wasn't actually an issue, but as we see from Lord Briggs' judgment, the court considered that, in fact, the forum convenience for that claim was Zambia. But because it was disabled by a WUSU from staying that claim, the question was what to do about forum convenience vis-a-vis the second defendant. And then we then move to 75, an important part of the judgment on the relevance of undertakings and the claimant's choice. So 75, Lord Briggs says he's been troubled by the absence of any particular focus by the judge on the fact that in this case the anchor defendant Vedanta had by the time of the hearing offered to submit to the jurisdiction of the Zambian court, so the whole case could be tried there. This did not, of course, prevent the claimants from continuing against Vedanta in England, nor could it give rise for any basis of displacing Article 4, but it does lead to this consequence, namely that the reasons why the parallel pursuit of a claim in England against Vedanta and in Zambia against KCM would give rise to irreconcilable judgments is because the claimants have chosen to exercise that right to continue against Vedanta rather than because Zambia is not an available forum against both defendants. In this case, it's the claimants rather than the defendants who claim that the risk of irreconcilable judgments would be prejudicial to them. Why, it may be asked, should that risk be a decisive factor in the identification of the proper place, when it's a factor which the claimants, having a choice, have brought upon themselves? And he then looks at 76 at the judgment of Mr. Justice Leggett. He says at 77, if the judge, if Mr. Justice Leggett was correct, then Mr. Justice Coulson was correct to rely on it. But he says in 79 that he's come to the conclusion Mr. Justice Leggett was wrong, and it shouldn't be a decisive consideration. So 79, after anxious consideration, comes to the conclusion that Mr. Justice Leggett's analysis, followed by the judge, is wrong. And then picking it up at 82, if the risk of irreconcilable judgments is one which, as in the present case, exists only to the prejudice of the claimants, I can see no possible reason why a right to sue in England under Article 4 should not give rise to the same choice if the alternative jurisdiction lies outside of that member state, outside of the member states in a place where the claimant may sue all the defendants. And then picking up at the last sentence of that paragraph, in short, if the Article 4 right is not a trump card for the purposes of avoiding irreconcilable judgments within the confines of the member states, why should it become a trump card outside those confines? I didn't take the Lordships to the consideration of the position within the EU, but that's what the Lord Briggs is referring to. And then paragraph 83, the recognition that claimants seeking to avail themselves of the Article 4 rights are nonetheless exposed to a choice, even in cases where it's not Brussels regulation, is, to my mind, the answer to the conundrum posed in paragraph 40. And that was where the judge, Lord Briggs, identified the problem that he was looking at in this case, which stemmed from a WUSU. It does not in any way bring into play forum convenience considerations as a reason for denying claimants access to the jurisdiction of England as a member state against the anchor defendant. It simply exposes the claimants to the same choice as is presented by a combination of Article 4 and Article 8 in the EU context. And then 84, the analysis does not mean when the court comes to apply its national rules of private international law, the question whether to permit service out, that the risk of irreconcilable judgments is thereby altogether removed as a relevant factor, but it does mean it ceases to be a trump card, and that the basis upon which the judge, following Mr. Justice Leggett, regarded it as decisive involved an error of principle. and we say that's very important. And so it's not a trump card, even if you can't stay against the first defendant because of a WUSU, it's not a trump card. We say the risk of inconsistent proceedings isn't a trump card either way. It's a really important factor, but it's not a trump card. And then 85, we don't need to look at that in detail, but Lord Briggs is looking at the connecting factors which the judge held pointed to Zambia for the claim, the trial between the claimants and KCM. And then the only factor he identified to the contrary for claimants and Vedanta was the risk of irreconcilable judgments. And then 86, he says, obviously you could have good case management of the English claim. It could proceed here with different modes put in place. And 87, in conclusion, it's sensible to stand back and look at the matter in the round. We agree when you've done the detailed analysis. This case seeks compensation for a large number of extremely poor Zambian residents for negligence or breach of Zambian statutory duties in connection with the operation of a Zambian mine. If substantial justice was available to the parties, it would offend the common sense of all reasonable observers to think the proper place for this litigation to be conducted was England. And then a few lines down, for those reasons, I would have concluded the claimants had failed to demonstrate that England is the proper place for the trial of the claim against these defendants, having regard to the interest of the parties. And that section just below H, if substantial justice, it would offend the common sense, is what the judge quotes in 37. And in our submission, that is not a statement of principle. That is Lord Briggs applying his statement of the law to the facts in Vedanta. So, my lords, just to summarise about what Vedanta says and what it doesn't say. So what Vedanta says specifically, in the particular combination of circumstances where the court cannot stay the proceedings against the anchor defendant due to a WUSU, and secondly, the court concludes another form is the form of convenience for the claim as a whole, or the claim against the anchor defendant. And thirdly, the anchor defendant undertakes to submit to the foreign jurisdiction. So in those three circumstances, the risk of multiplicity of proceedings which arises due to the claimant's choice is not a trump card when you're looking at forum conveniens with respect to the claim against the foreign defendant, but it is still an important factor. So that's what we say Vedanta says specifically. Still an important factor. It's certainly less important than the courts previously thought, because they thought it was decisive. Maybe less important than in other cases, because the court is hampered in its consideration of forum conveniens overall, but it's still important. And as again, we say the ideal may be to identify a single jurisdiction, but the risk of multiplicity of proceedings is not a trump card. And I'll come back to the recent cases on that in a moment. But first of all, what Vedanta does not say. And we say it does not say that there's a new mixed case test, because that would elevate the risk of inconsistent proceedings to the status of a trump card. And it is wholly inconsistent with the approach and language used by Lord Briggs. We submit that the correct approach is to separately and sequentially look at these applications, respecting the starting points on jurisdiction and the burdens of proof and the role of forum conveniens in each case. And then to look at it in the round and stand back, but after the court has considered the issues in relation to each defendant. My lords, post-Vedanta, the courts have not been applying a mixed case test. I'd like to take your lordships to the judgment of Mrs. Justice Popplewell in...
Just before you do
yes,
that,
certainly.
Can I just ask?
Yes.
There's something that's troubling me. You start separately and sequentially, you say, with the stay application.
Yeah.
When you're considering that, in our case,
yeah.
A factor, an important factor, Lord Briggs, a very important factor, but not, you say, a decisive factor, is risk of inconsistent judgments in deciding the appropriate forum question. So when you're looking just at the stay application against D1 and D2, you get to the question, well, is there a risk of inconsistent judgments in this case? To which the answer is, well, it depends what I do with the set aside of the service out case. So how can you, in practice, look at it separately?
So you do need to, in our submission, you do need to factor it in when you're looking at it separately, because the court looks at the factors relevant to D1, D2, then looks to see who are the other parties or even potential parties, and factors that in, albeit they don't necessarily need to take a decisive decision at that point, but it needs to be done first.
But you can't do, there are two possibilities if you're looking at it separately. One is the claim against D3 will go ahead in Malaysia. The other is it'll go ahead in England. And until you've addressed which it's going to be, which is also a question for the court, how can you apply the risk of inconsistent judgments factor to the stay application?
Well,
that's what I'm having trouble with.
Yes, I understand that, my lord. In our submission, it's not a factor that's to be ignored. First of all, we would say that the court does look at the factors between the claimants and the UK domiciled defendant on their own, but then as part of that, the forum conveniens jurisprudence requires the court to look at the reality of A, the case before it, and B, as I say, even potential additional parties, and to factor that in. But it's not a trump card. Even if there is that extra claim, it cannot be a trump card over the assessment of where is the forum conveniens of the claim against the English defendants. So it shouldn't be a trump card either way. It's not a trump card that the court decides this is the jurisdiction for the claim against the English defendants. That's not a trump card when you come to look at the claim against the foreign defendant. But equally, when you're looking at the claim against the English defendants and what's going to happen to the other claim, the existence of that claim cannot, in our submission, be a trump card vis-a-vis the assessment of the forum conveniens on the English defendants. But the reason we say it's important for the court to do it separately and sequentially, and I premise my submissions on the back that it is really important then to stand back. I'm not saying that it's not a factor that the court takes into account. I'm not saying the court doesn't look at it in the round, but it's important to do it separately and sequentially because of the starting point that the court has jurisdiction over the English defendants, because of the burden of proof, and it's not a finely balanced burden of proof, and burdens of proof can, as we know, matter when things get close. And I drew your lordship's attention to the judge's use of the word tilt when he was looking at the libel proceedings. Didn't tilt it towards England. It sounded like it was quite finely balanced. If it's quite finely balanced, we say on the English defendant's application to stay, then they lose unless they clearly and distinctly. And then the court knows that that claim is proceeding or not proceeding. If they win, everything else doesn't matter. There's no claim against the third defendants. If they lose, then that claim is proceeding in the English court, and that is highly relevant, but not a trump card when the court comes to look at the foreign defendant.
I mean, this is a very mechanical process you're suggesting, whereas maybe it's a little bit more nuanced. What slightly troubles me is that if you do the exercise you're suggesting and do it in compartmentalized bites, you may allocate weight or lack of weight to a particular factor inappropriately. Plainly, you're right in saying that one factor the judge had to take into account was that there were 2 English defendants resident here with 3,000 employees, and that much of the claim was about what they'd done here. But equally, he had to take into account that there was a Malaysian defendant of I don't know what size or scale, but anyway, a Malaysian defendant as well, who the claimants wanted to sue. Why shouldn't the Spiliado exercise, bearing in mind the different standard of proof and the different burden of proof, be undertaken as a whole? Where then you give due weight to the balance between not having irreconcilable judgments if there are separate proceedings in Malaysia, or having irreconcilable judgments if there are, to both cases at the same time without doing some artificial compartmentalization? Why is it so critical to your case that you have to have compartmentalization?
So, my lord, it's not critical to our case that we have compartmentalisation. So it would be fine if the court looks at all factors together, but does nonetheless respect the burdens of proof and the standards of proof, which we say are significant. So it cannot be done as one exercise. We say the risk of doing it as one exercise, as the judge did, is that you forget about relevant factors like the connecting factors relevant to the UK defendants, for example.
Well, I don't see why that's a risk. I mean, he may have done, in which case that's a ground of appeal, but
yes.
It's not a... I mean, cases are not decided on the burden of proof, we all know that. I mean, it may be critical in some cases, but cases are decided on their facts. And what
Absolutely, my lord.
You know, I'm struggling with is, why is it so important to your appeal that you have to do the exercise? You have to start with the anchor defendant. I mean, of course, the fact there is an anchor is important, but you have to start with the why should you not start with the third defendant? And why does it matter? All you're really saying, surely, is that the factor that these two main defendants and everything that sailed in them, if I can put it that way, was here, was a factor that should have had a great deal more weight.
Well, my lord, we do say that the approach matters because there is a danger if the defendants are not looked at separately, that the relevant factors are not taken into account, as we say the judge did not take them into account. We also say that on the basis of Spithiada, it is quite difficult to do it all in the round, given the different burdens and standards. And I hear what your lordship says about burdens, but that's part why I took your lordships to...
Can I just ask you
Yes.
this, which may be bringing to the surface something that will otherwise remain under the surface? Are you worried that if you don't show that there was this error of legal approach, you can't succeed because it was a matter for the judge's discretion?
Absolutely not, my lord, because we say that the
Absolutely
judge obviously left out of account factors which on any view are important connecting factors, so the domicile and connections of first and second defendants, the fact that the critical acts happened in England are the two big factors we say into account. We also say that there's an obvious error.
Why don't you concentrate on that?
I'm very happy to do so. But if I may, my lord, I take your lordships to the judgment of Mrs. Justice Cochrane.
Just before you do, whilst we've blown you off course, can I just ask you the slightly separate aspect? You said that deal with them separately first and deal with the stay application first. I think you said, tell me if I'm wrong, because it's a necessary and proper party case.
I did, my lord. I said that. And
So does it follow that if you had a case in which the grounds were tort committed here, then you wouldn't be saying start with
well, I think,
English?
I say it doesn't matter so much. The reason I said what I said in relation to the necessary and proper party ground is that if you start with the foreign defendant, you have to make a lot of suppositions in terms of the gateway before you look at forum convenience. But I would accept you could do, you could do the foreign defendant first and then the English defendants. I'm not so attached to that order, but I am attached to the fact that, or I do submit that it's important to consider separately the factors. Not least, I mean, the Spithiada test focuses in on the interests of all the parties and the ends of justice. And I think there's a danger, and in our submission, the judge fell into this error, that if you look at it in the round, you don't focus actually in on the relevant connecting factors for those individual parties.
Well, if you took the application to set aside the service on the third defendant separately and independently, and ignored the fact that there are also English defendants, we might have an uphill struggle.
Well, I wasn't suggesting, my lord, as I didn't suggest that you ignored the third defendant when you looked at the
but
first and second.
when you say you're not really wedded so much as to which order you take them in, it does seem to me that it is rather important for this aspect of your argument
But it's
But you have to
important on
take the
this,
stay
the necessary
first.
improper party. Otherwise, as I said to your lordship, you have to make a lot of assumptions before you can really consider the point on forum convenience, which is why I say it makes more sense to do it separately.
But that's the problem with this point of principle that you're raising, is that you can't lay down rules as to which application in a particular kind of case you take first or second or in the middle. You're dealing with the whole case, as you yourself has highlighted in looking at the Spiliada and Vedanta. And I think you're making a fantastic rod for your own back, if I may say so, because you're asking us to lay down some fabulous principle that you do this first in this case, in another case you might do that first, and absolutely, if you get it wrong, woe betide you when you get to the Court of Appeal. And, you know, for my part anyway, I'm very reluctant to lay down strict rules of that kind unless they're absolutely imperative and demanded by law or statute. I don't see that here. No. So show us, if you will, Alagad, is it?
Well, I'll look very briefly at Alagad in light of your lordship's.
Well, I think they rely on Alagad. So
Alagad, I think. It's in volume 3 at 36. And really the point I want to make from Alagad is that it's a post-Vedanta case.
Sorry, it's what?
A post-Vedanta case.
Post-Vedanta.
3, tab 36, page 1296. It's a post-Vedanta case, and it fits into the definition of Malanfred's mixed case, or the judge's mixed case, where you have serves in and serves out. But in this case, Mrs. Justice Popplewell did not look at the question just as a one-part question, where should this claim be heard? She did do it sequentially, and certainly my reading of the judgment was that she thought it was important to do it sequentially. So it's page 1296 of the bundle, and it's I think March of this year. It's as you see from paragraph 1, it's a family dispute. There was a jurisdiction hearing. The third defendant was served at Heathrow, so that was the presence in. The service in was when someone was passing through at Heathrow, and the third defendant was used as the anchor defendant. The other defendants were out of the jurisdiction, and service out was applied. Permission to serve out was applied for and obtained, and this was the challenge for all of the jurisdiction disputes. And so if I can pick it up at paragraph 9, page 1298, Mr. Justice Cocker says the Lama, third defendant, was used as anchor defendant to obtain permission to serve the brothers out of the jurisdiction under the necessary and proper party gateway. And then 11, the legal test applicable in a foreign non-convenience application remains that outlined in Spiliada. And then I think, just taking it very briefly, 15, as Justice Cocker says, because of Lana's status as the jurisdictional linchpin, I will therefore deal first with the Lama jurisdiction dispute and then pass on to the brothers' jurisdiction dispute.
That's just what she decided to do.
That's just what she decided to do.
I'm not saying it's a matter of law.
Absolutely. But what I'm saying is there's nothing in Vedanta which suggests that you need to adopt a mixed case test, a different type of approach, because obviously that's not being applied in this case. And then just picking it up at 20, the legal principles, stage 1, the court will look to various factors, including the subject matter of the dispute, the governing law, the location where the relevant conduct occurred, the location of witnesses and evidence, the place of incorporation of any companies connected with the disputes, and the personal connections. Seeing if there's anything. And the court looks at the Lama dispute and then turns to, if I could just pick up in looking at stage 1 of Spiliada, so 41 is where she starts.
But it was common ground in this case that at stage 1, Saudi Arabia was
Absolutely,
appropriate
absolutely.
forum,
And so
it wasn't a stage 1 case at all.
no, that's
Sorry.
correct, my lord.
More
But it may be that in the circumstance I don't need to look further at Allagat. I only want to make the point that it's not that there is a new mixed case test from Vedanta. It certainly hasn't been being applied by the courts. And the courts often, and we would say sensibly, do take a separate approach. The Mariana case.
Well, Mrs. Justice Cockrell said what the Spiliada test was and then sought to apply it.
My lord, yes, absolutely. Because I think I will leave my submission there in terms of the separate and sequential.
We'll see what Mr. Gibson makes of it later.
I think your lordships have my submissions about why we say it matters in terms of each defendant being an individual party, different jurisdiction rules, different connecting factors.
You mentioned Mariana, and I took.
Well, just to say about Mariana that in Mariana, just again, it wasn't a mixed case, but it was a case where there was different defendants governed by different jurisdiction rules, and the court did take a separate approach to looking at each of the defendants. And
that's my lord, is it?
Yes, absolutely.
Right.
It's not the important.
But I don't need to go to that. But just finishing then on the importance of inconsistent judgments, I do want to take your lordships to a decision of Mr. Justice Jacobs in the Rumi case, which I think is in the additional bundle.
It's not actually, it's all by itself.
Oh, is it all by itself?
Well, anyway,
I hope you've got the correct page numbers, my lord.
Well, it's
should
one
be
case. I've got
tab
one
3,
case.
page 313.
I should be able to find my way around one case. If you give me the paragraph number, you want.
Tab 313. It's just to highlight that, again, that Vedanta hasn't changed things in terms of inconsistent proceedings. So if I can just pick up, in this case it wasn't a mixed case, so both the defendants were served in. But paragraph 66 we could turn up in the judgment of Mr. Justice Jacobs. The relevance of existing proceedings in England. The first sentence is important. It's clear on the authorities prior and subsequent to the decision of Vedanta that the avoidance of fragmentation and risk of inconsistent judgments is often a significant factor. This is so both in the context of applications served out and in applications where the burden lies on the defendant. And he refers to the authorities pre-Vedanta, including Tugashev and Orlov, which is in the bundle, but I wasn't going to take your lordships to. But Mrs. Justice Carr, she was then in that case, refers to and cites the helpful in our submission passage from Mr. Justice Christopher Clark, as he then was judgment in BTA Bank and Grantham. That's paragraph 68, looking at cases where you have more than one defendant and the impact of proceedings against one against the other. And particularly we highlight the distinction Mr. Justice Clark drew between major and minor players. Just picking up 68 in the quote, it fails to distinguish the case in which the anchor defendant is the chief protagonist from the case where he is a minor player. A decision that permission should be granted to serve the protagonist out of the jurisdiction because the minor player is domiciled within the jurisdiction would indeed allow the tail to wag the dog. But if the anchor defendant is the protagonist, a decision to allow a minor player to be served out may be entirely appropriate. That would be to continue the metaphor, to allow the dog to wag the tail. Just as it may make little sense to have the venue determined by where the claim against the most insignificant player will be heard, so it may make little sense to have the venue where the most significant will be sued, passed over in favour of another jurisdiction to whose jurisdiction a lesser player is subject. I do not mean to suggest that whether or not jurisdiction should be exercised against a foreign defendant is necessarily determined by whether the anchor defendant or the defendant sought to be joined fits into some particular descriptive category, only that a decision must necessarily take account of the relative importance in the case of different defendants. And then putting Lord Briggs and then the case of my lord in EDF and Mann.
And did you say in this case D1 and D2 fall into the category of chief protagonists.
We do.
And D3 minor player.
I'm not sure we say minor player, but certainly chief protagonists and principal defendants. And as I said in opening, we had it intended only originally to sue D1 and D2, but due to correspondence from D1 and D2, we joined D3 as they do seem to be have significant a significant role in the subject matter of the claim.
Is that somewhere in Mr. Holland's evidence?
It is, yes.
Someone could give me a reference in due course.
Yes, absolutely. All I want to say is about Vedanta is that to the extent that it marks a change in the law, we would say it is old news because it applies only where the forum conveniens was not available with respect to the first defendant. It does not require a different approach in claims with multiple defendants. To the extent that it affirms the importance of the risk of inconsistent proceedings, it is not news. We all are on the same page. So, my Lord, moving to the second part of Ground 1A, which is obviously related to the first, that the judge ignored or at least attributed no weight to the strong connections of the first and second defendants to England. My Lord, if we can, so we can look back in the judgment, the conclusions at 122 and 123. In those conclusions, the location of the parties and their connections are not mentioned, and I appreciate obviously that's only the conclusions. In 123 there's a reference to the location of some of the acts and omissions taking place in England, but not the connections of the defendants, so nothing about them being incorporated here for more than 30 years, the thousands of employees here. It's also revealing, we say, to look at his consideration of Spiliada stage 1. So the headings from Lord Briggs's factors. So the first heading, which is at 84, I think, is on practical convenience. So neither England nor Malaysia are practically convenient for all the parties and witnesses. Wherever the claims are heard, there will be some parties and witnesses for whom that location will not be convenient. This factor is essentially neutral. And then 85, D1 and D2 and the likely relevant witnesses are located in England, and so England is convenient for them. And we say that the judge focuses only on practical convenience in this section. First of all, his heading, but also the wording he uses in 85 suggests he's looking at the practical convenience.
You say that's an error, do you? Because everybody ever since Lord Gough has said forum convenience does not mean convenient.
It doesn't mean convenience, and the location and connections of the parties are one of the key connecting factors. Nothing to do with their convenience, but where the party is present is highly relevant.
Suitable, not convenient.
Suitable
or appropriate. Yes.
Not convenient. And then looking at heading 2, so the issues in this case, which are at 102. I'll come back to that actually when I do Ground 1B, the place where the wrongful act and damage occurs. And then 103. I'm sorry, my lord, slightly lost. Oh yes, 103, the judge says, this is where he's dealing with the claims against the Dyson defendants are contingent on whether the underlying mistreatment occurred in Malaysia. If it did occur, the claims against D1 and D2 fail. And he says, even though D1 and D2 are situated in England, but he's really just looking at the place of the activities here in my submission, which is why I'll come back to it in the context of 1B. There's nothing in the remaining paragraphs that we can see on the location and connection of D1 and D2. So it is all about practical convenience. And as your lordship says, I say that's wrong based on Spiliada, because it's not just convenience. and it's an important factor. And I say that the judge may have focused only on practical convenience because he used the dicta of Lord Briggs, which was only a dicta which is intended to highlight some of the relevant factors. It happened not to include the location and where the parties carried on business, which Lord Gough in Spiliada did highlight in his list, which was also not comprehensive or intended to be, but had a different focus. My Lord's presence has always been a key connecting factor and indeed a foundation for the English court's jurisdiction. Historically, at common law, the court administered justice for everyone who was present, even temporarily, in the jurisdiction. And we say that is a really fundamental point. A defendant who is present in the jurisdiction and is served, the English court has jurisdiction as a result of that presence and service, regardless of domicile. Even temporary presence is sufficient. So if the claimants had chosen to sue Sir James Dyson, he could have been served if he'd been passing through Heathrow Airport, and that service would have founded jurisdiction. Companies can be served if they're present in the jurisdiction. Obviously, temporary presence is less likely. I think some of the older cases showed companies being served at trade fairs where they were there for a few days. Overseas companies can be served in the jurisdiction at any place where they carry on business or carry on their activities. But a company who's registered in England and Wales can be served at their registered office. And that, we say, is the strongest version of corporate presence. The companies D1 and D2 are incorporated under UK law and they're registered in England. And I will give your lordships the evidence references for those. And we say it's not surprising that the location of a defendant has been important in the court's jurisdiction. It's important in lots of systems of law because a defendant is thought to be better placed to conduct their defence in their home courts. My lords, I was going to take your lordships briefly to Connolly, decision of the House of Lords in Authorities Bundle 1, tab 3. Tab 3, page 89, Judgment of Lord Gough. Again, I think we can pick it up at 873. I just want to take the lordships to it for a short point. So this was a claim against a defendant, an English company. I'm just picking it up at 873, so 89 of the bundle, between A and B. Lord Gough says, I wish to interpolate at this stage. There's no question of the plaintiff in this case having founded jurisdiction.
I'm so sorry, I'm not.
I'm so sorry.
Where are we?
So page 89 of the bundle, tab 3 of volume 1.
873.
873 of the report.
No, sorry, I'm not in the right case. Where?
Oh, I'm sorry, so sorry. So volume 1, tab 3, page 89 of the bundle.
Thank you. I've wasted all the time you saved by having the numbers in the right place. Sorry.
I'm so sorry, my lord.
We'll digitise Lord Justice Popplewell in the end.
Well, and Mr. Gibson and myself, my lord.
Yes.
So just between A and B, 89 in the bundle, 873 of the report. I wish to interpolate at this stage, there's no question of the plaintiff in this case having founded jurisdiction against the defendants on what may be described as an extravagant basis. In a case where the plaintiff had done so, for example, by serving proceedings on an individual while on a brief visit to this country, the court may not be prepared to assist him by refusing a stay to enable him to keep the benefit of an advantage available. And then a few lines down. Here, however, the plaintiff founded jurisdiction as of right by serving the two defendants in the country, both of them being English companies registered here. No doubt their domicile in this country, coupled with the availability of financial assistance here, has encouraged him to select them as defendants. But I cannot see that of itself exposes the plaintiff to criticism. If he was going to sue these defendants, this was an appropriate jurisdiction in which to serve proceedings on them. then for the defendants to persuade the court, as they're seeking to do, the action should be stayed. So it's a very simple point, but that an English company registered in England, it's not a surprising place for them to be sued. And obviously, as we were discussing earlier, there are cases where a company is simply registered in the UK, but really is a matter of formality. In Vedanta, the lead defendant only had 19 employees.
Well, I mean, you say, I mean, this is a very simple point, I'm sorry to say. You say it was blindingly obvious that these were two very large English companies that would naturally be sued in England, and the allegations against them were that they'd done bad things, you say, in England, and you'd have to really surmount a fairly large hurdle to chuck such a case out to another country. And that starting point may not be the finishing point, but that starting point seems to have not been emphasised by the judge.
Yeah, absolutely, my lord. So, my lord, if I could take your lordships to the evidence on the strength of the first and second defendants' connection due to their presence here. So, your lordships will find this in the core supplementary bundle.
Sorry, you're on evidence of D3, are you?
No, evidence of D1 and D2 connection.
So, core supplementary bundle.
Core supplementary bundle, tab 2.
Is that sub 1 or sub 2?
Oh, so it's just, there should only be one core supplementary bundle. There may be multiple supplementary bundles.
Okay, well, I've got
But core supplementary bundle.
I've got the supplementary bundle as well.
Yeah.
I hope there's a core supplementary bundle.
Yes, I've got it. What
Yeah.
page?
So tab 2, page 8 is the witness statement of my instructing solicitor, Mr. Holland. This was filed in support of the application for permission to serve out on the third defendant. And if I could take your lordships to page 32, you'll see in paragraph 75 that Mr. Holland sets out the strong connection between England and the facts and circumstances giving rise to the claims, particularly the 2 of the 3 defendants domiciled in and operate from England. Should as of right their address, and then 75.3 Dyson UK office remains the primary operational control centre for Dyson Group with at least 3,500 employees based there, including key operational staff relevant to these claims. And then 75.4 central issue in the claims concerns the creation, promulgation, and enforcement of various policies which bear the name of the first defendant, and which state they were reviewed and approved by individuals who it's inferred were employed by the UK defendants, and a reference to the particulars of claim. It's therefore very likely that those policies were devised and formulated in English. Obviously, we don't have the information on that as yet.
Can I just ask this? 75.3,
Yes.
second half of it, is there any evidence to the contrary? Is this the evidence on that topic?
I don't think there is, my lord. I'll just... No, I don't think there is, my lord.
Thank you.
And, my lords, if I could also refer your lordships to the skeleton argument at first instance, so that you see what the judge had. It's in for supplementary bundle tab 11. It starts at 349, but if I could direct your lordship's attention to 366. And my lords, you'll see there that over the course of the following 4.5 pages, the strong connection between the first 2 defendants is set out by reference, including other things, to some of the evidence we've looked at. Yes, in that same, yeah. Oh yes, and Mr. Craven points out that earlier in the skeleton at paragraph 23, there's a section on the central role of the UK defendants.
Sorry, I've missed my place. Where are we in the bundle?
So bundle reference 360 is the section C3 of the skeleton, which is the central role of the UK defendants, and then I was looking at 366, which is focusing in on the strong connection with England and the employees and the the names of the different defendants who are on the different policies. And my Lord Justice Popplewell asked for the reference to the evidence that the claimants originally intended to pursue the claims just against the UK defendants. That's in paragraph 109 of Mr. Holland's witness statement. So the same bundle that we are in, tab 2, page 48.
Thank
In other words, it was also common ground that an important argument regarding appropriate reform for the claims was the fact that the first and second defendants were domiciled in England. If I could direct your Lordship's attention to the first statement of Mr. Ledley, which is in 4 supplementary bundle, tab 6, at page 69.
What's this for? Just that it's accepted they were domiciled. They're domiciled in England.
And that our case principally rests, the witness statement says, on the fact that the first and second defendants are domiciled within the jurisdiction. I was just saying it was common ground that that was our case, and in those circumstances, particularly striking, the judge does not really, we say, engage with that issue in his judgment. And if I can just, before the adjournment, address the point about the undertaking. The undertaking by the first and second defendants to submit to the Malaysian jurisdiction. The reason I'm doing this is because at first instance it was suggested that the undertaking somehow impacts on the evaluation of the strength of the connection of the first and second defendants to the UK. In the first instance skeleton of the respondents, at paragraph 98A, I'll just read the paragraph, but I'll give you the reference. Core Supplementary Bundle, tab 10, page 317. It said that in circumstances where the English defendants have undertaken to submit to the jurisdiction of the Malaysian courts, their involvement is a neutral factor in stage 1. And my Lord, we would submit that that's simply not correct. The first element of Spiliada requires the first and second defendants to show there is an available forum, and the undertaking just ticks that off. So there is an available forum, but it doesn't go beyond that. Last reference before lunch is Lord Hope's judgment in Lubby in the House of Lords, Authorities Bundle, Volume 1, tab 17. Page 183. Oh no, wrong reference. 7, tab 7, page 183. 183. So 183 F to G, Lord Hope just refers to the fact that the only ground on which the foreign courts are exercising jurisdiction is prorogation, so the undertaking is critical to that. And then if we could pick it up, 185, which in the bundle is, at 185, at the bottom of 185, last line, nothing turns on the time the undertakings were given. Sufficiently were before the judge when he was considering the question of form convenience. As for the suggestion the defendant was choosing the jurisdiction, thus indulging in kind of form shopping, this overlooks the fact that the issue of form convenience is for the court itself to resolve. It's not a matter that's left to the choice of the defendant. And then reference to the test. And then just below B, the only purpose of the undertaking is to satisfy the requirement the other form is available. The ground on which jurisdiction of the courts in the other form is available to be exercised is of no importance either one way or the other in the application to the case of Spiliada. And then I just draw your Lordship's attention to the end of that page at little h, just stressing the Spiliada approach.
No doubt the public policy point at D.
Absolutely, my lord. That public policy point we're going to come back to when we look at applicable law, but your lordship is quite correct just to pick it up there, that no considerations of public interest or public policy are to be taken into account in the context of foreign convenience. And at 186H, in my submission, a very clear summary of the principles from Lord Hoop. The proper approach is to start from the proposition that a claimant who is able to establish jurisdiction against the defendant as of right in this country is entitled to call upon the courts of this country to exercise that jurisdiction. If the plea of foreign convenience cannot be sustained, the jurisdiction must be exercised. My lord, is that convenient?
Very convenient. 3 minutes extra convenience, I would say. And we will resume, thank you, at 2 o'clock.
Thank you very much.
Court rise in favour.